Next on the agenda, we have a discussion about 2025 WSBA legislative priorities. And I'm going to now turn to our Ledge Committee Chair, Governor Kevin Fay.
The first question I have is Sanjay is on the line. Never mind. Yes, I am proud to serve as the chair of the Legislative Committee. We monitor the actions that are being taken in the legislative session and have weekly meetings to see what our legislature is doing that may or may not affect our, the bar and what the bar does. Our legislative priorities, except for one proclamation that will be discussed later, are unchanged. They're longstanding, largely unchanged, and seek to make improvements to the practice of law and the administration of justice. The priorities document is primarily used to inform legislators of the Bar Association's focus areas during the legislative session, and the priorities are drawn from the Washington State Bar Association Guiding Principles and GR 12.2. The rest of this presentation will go much as our meetings of the Legislative Committee go, where we sit around and listen to the wisdom of Sanjay Walkar. So I will defer to him and his presentation. Thank you, Sanjay.
Thank you, Governor Fay. Good morning, all. I'm here really to just sort of emphasize what Governor Fay has said. These priorities are longstanding. They are largely unchanged from years past, but I do want to note two important additions this year. In the second bullet point on the priorities document in your materials, we've added support for public defense funding. And that is an effort to continue to support the new indigent defense caseload standards that were approved by the board earlier this year. And I also want to call your attention to the last point that calls for us to study the effects of a non-unified court system. And Governor Fay mentioned the discussion on that. This is tied to the draft proclamation in your materials that was approved by the board's legislative committee last month. And we've heard this topic of a non-unified court system, disparate court rules, mentioned a couple times at yesterday's strategy planning session. And I do want to note that we've been hearing from members for years that the lack of a statewide unified court system is really impeding access to justice. We are aware of legislation this year to create a commission to study this issue, specifically looking at how disparate technologies and funding sources across counties, across the statewide court system can impact access to justice. So we've been in close contact with Representative Jamila Taylor, who is the chair of the House Civil Rights and Judiciary Committee and the primary driver of this effort. The proclamation before you supports that effort. It puts this issue squarely in our legislative agenda for this year, and I think takes a really good first step to responding to members' concerns about disparate court rules and court systems and lack of access to justice. As I mentioned just a minute before, this proclamation was adopted by the board's legislative committee last month. What we're asking for here today is adoption of the entire slate of priorities, including the proclamation, and I'm happy to answer any questions.
The priorities and the proclamation can be found at pages 114 to 115 of your materials.
I think Governor Williams-Ruth has a question or comment.
I do. And again, this is one of my great failures as a governor in that I came in wanting to see a unified court system and then learned about what it would take to actually change. Now, I am a huge fan of even if there's not going to be a positive outcome, to study the times, such as, changing our fiscal year to the calendar year. But we've looked at this unofficially, but we know that to change this would require a constitutional amendment where every single county clerk would have to give up their fiefdom of their existence. And it's been determined that that's just not going to happen, that there's no support for it. The county clerk, I mean, all you have to do is talk to our AOC folks and the difference between King County and their e-filing in their world and the Odyssey filing world and the fights that happen between them. And this is, in my opinion, the Social Security third rail issue of politics in Washington legal world. So my question is when there's absolutely no pathway to change, we know what it's going to take. Why are we going to spend time, money, resources, staff, and volunteer energy to get something that says, yes, this would benefit our state? Absolutely. The world would be better if we had a unified court system from small claims district court all the way to the state Supreme Court. In my opinion, again, some people may disagree. In my opinion, that would be the promised land. But again, I don't understand the value and virtue of what would be achieved by investing so much time to do this when there's no pathway at all for success. I mean, I could have really created a pathway for a fiscal year lining up with the calendar year, but it still didn't happen. I just don't know why we would want to go down this road.
I think Executive Director Nevitt would like to address that question, and then Governor Ahern,
And then Jordan.
and then Governor Couch.
Yeah, I mean, I think I was sort of feeling similarly that this has come up every year that I've been at the organization. And whenever I would talk to people about it, they'd sort of like pat me on the head and say, oh, isn't that a cute idea? But I think, you know, some folks, including our Chief Communications Officer, Sarah Nagowski, have never dropped it and keep talking to people about it. And I think the truth is we're not driving this. There are legislators that are driving this, and they'll do it with or without our support. And I think they believe there might be some movement, that there might be some momentum even among clerks. So I don't know what magic wands they have, but I think that we'd like to be supportive of it. I don't believe that it will end up costing us any time or money. I mean, time a little bit. Obviously, I hope we will participate, but I don't believe we will be funding the study. I don't believe we will be running the study. I think we just want to be supportive and be able to rally the legal community to say, like, yes, we support this. And I will also say Representative Taylor came and made a presentation to the Board of Judicial Administration. And that it went really well. I do think there's some openness. So, and we also think that starting with a study is a really good idea, because hopefully it will reveal exactly what needs to change. And it might be something less than a fully unified system. It might be unifying the technology. It might be unifying the court rules, but hopefully a study will help get us there.
Thank you, Director Nevitt. Governor Ahern, then Governor Couch, and then Governor Fay.
Okay, addressing what's on page 114 and 115, I have 4 comments or thoughts or whatever. First, with respect to the study, I think it is important to actually have those minor trivial things called facts when we're trying to, propose something. So I agree with the study thought. My only concern is it's very easy to say we're going to have a comprehensive study, and we want it to be really thorough. So it's going to be a 5-year study, and we'll look at it 5 years from now. So I'm concerned about it being delayed, but I'm still going to support it because I think a study is important. Point 1. Point 2, on the it's impossible to do because we're not going to ever get a constitutional amendment passed. I think there are ways to prod what would be certain aspects of a unified court system, like a Supreme Court can issue a rule that we're not going to have local rules anymore, period. You're done. These are the rules in our state courts. You could also prod everyone to have the same e-filing system. If the state fully funds a really good system and says, hey, counties, if you want to have your own thing, fine, have it. You're paying for it. And especially the more cash-strapped counties, I would think they'll take the freebie rather than their own. Point 3, with respect to then under the second big bullet, and then the last two of little bullets underneath that, with the adding the public defense services, I just want to make since my thought on all of this is public defense services are part of Gideon versus Wainwright. And that is the third sub bullet there. That's funding the state court system. And I don't like to me, I don't like separating it out because frankly, I also think that what county should do is just file a suit demanding the state fund under Gideon versus Wainwright, the defense cost. That's another issue. Pardon?
Yeah, that's happening.
Okay. Well, I've seen, well, we can talk later about that. And then my fourth point, though, is on the first bullet on supporting legislative proposals initiated by the sections and approved by the board. I do not, and I think we might be discussing this at a later meeting or something. I don't think the board should be taking section proposals and pretending like we're the experts and we actually understand everything. I'm strongly supportive of letting the sections propose things and the sections do stuff, but I'm very uncomfortable having the board sign off on section things when the board members don't fully understand it as well as the section folks do. But anyway, those are my 4 comments.
Thank you, Governor Couch, and then Nancy Hawkins. Oh, I'm sorry. And then sorry about that, Governor Fay. You are ahead.
So regarding the local court rules funding technology, it's funny, until Governor Williams spoke, I was planning to say, why do we need to do a study? We all know for a fact there is a problem. Any of us who've practiced law in multiple counties are very aware of the problem as lawyers, let alone people who are not legally trained. After hearing Governor Williams speak, I thought, okay, so actually we do need to do a study because we need to have the hammer of facts, of data that we can unite people around. And I do think this is a possible thing if we have something like this, because I will tell you, 8-ish years ago, I was working with the ATJ board's tech committee talking about this, where we had regular meetings with all the different court stakeholders. And what they all told us was basically what Governor Ahern just said. They're happy to do it as long as you're not telling them they have to do 3 times the job with half the staff. That's their problem. So these things are possible. And I think if we have something where we can bring, some data to bring all stakeholders around, the legislature, the courts, the different court programs, us, the ATJ board, this is a very doable thing. One question I just had, just language on this, on the legislative priorities, monitor and take appropriate action on legislative proposals that would increase existing court user fees. Is that, is it just because they're never going to be decreased, so we're not worried about the risk of them being decreased? Because I would love to see them be decreased. I just don't see that happening, but I would want to make sure that was what the reason was, that it only says like increase existing court user fees. Like,
Governor Fay? Yes, Sanjay, do you have a clarifying response to Governor Couch's question?
Yes, only to say yes, Governor Couch. That's the reasoning.
Governor Fay and then Nancy Hawkins.
At the legislative committee, we had a discussion on, we all know this is a problem. It's been a problem. Why don't we just go ahead and say, let's fix it? And the answer is that wouldn't work. The idea of a study, which by the way, we are not the studiers, although we may be asked to participate, is to shed sunlight on the dirty little secret that justice and courts are vastly underfunded in the state of Washington. And unless you shine a light on the fact that a lot of poor people are getting screwed simply because there isn't an adequate judicial infrastructure, judicial, yeah, good enough, infrastructure in place. People have difficulty practicing across county lines, but there's just so many things that could be done if the state legislature were to do things a little bit differently. Now, Jordan referred to the hammer that the study could be. I prefer thinking of it more as a baseball bat or a 2x4, where you can smack the legislature across their head and get their attention. Because until the attention of the public is that, hey, this is really a bad thing, no one's going to do anything. You got to get their attention And as far as we can tell, this study, the people who are proposing doing this study think that this is the at least best initial step to getting at least some stuff done. And the question isn't whether we're going to do the study or not. The question is whether or not we are going to support what what Representative Taylor and her colleagues are trying to do. Now, personally, I don't know if we want to propose it or not, but that's not what we're being asked to do. We are being asked to support the ongoing effort of some legislatures to try and fix a problem that we all know exists. So I'm going to be out of turn, and well, I won't be out of turn. I move we adopt it.
Nancy Hawkins.
Sorry, seconded.
Oh, okay. Thank you, Gordon, Governor Couch. Nancy Hawkins, and then Mary, Governor Rathbone, and then Governor Bloom.
Thank you. These issues are well known to probably this board and prior boards, because for many, many years, there's been work done by the administrator of the courts to try and get out the word and come up with solutions. So I imagine there's been some communication with these legislators and the administrator of the court, and I see Sanjay nodding his head. So this isn't something that would be imposed by King County with a bat or without a bat. And it would be very important for it to come from the administrator of the courts or legislators, as opposed to a organization that's always going to be viewed as controlled by King County. The easier is going to be the technology, getting everybody on one court system so e-filing can happen in the same way across county lines. It is really just a money issue, and then which company are you going to use? You know, which software? And I imagine somebody's going to be willing to cough up some money so that it's their company on an ongoing basis. The court rules issue is far more complicated because, and I'm sure Kari and others who practice in smaller jurisdictions, and Mary, understand that there are court rules that need to be more complicated for bigger counties, and all of those complications aren't needed for smaller counties. I've occasionally practiced in smaller counties where when I said, well, what's my deadline for filing a motion? And I'm told, well, just send it up here. We'll hear it tomorrow. You know, it's no big deal. Well, that just doesn't happen in King County. But so making one set of court rules that applies to every county in the state is very complicated, and it's complicated for good reason. And either larger counties are going to have to give a little, or smaller counties are going to have to add layers of complication that they don't want or need. So that's a study that we shouldn't focus or let this investigation get focused on court rules. Let it solve the technology issue would be my suggestion. The issue of increasing court fees. Every time there's a problem, court fees get increased, and that falls very heavily on pro se litigants. And frankly, it falls heavily on lawyers who end up fronting those costs and then waiting to get paid, or getting paid where the money goes towards court fees instead of towards our hourly rates. So the idea that we might lower fees in the future, a good idea, Jordan, but probably not realistic, given that once you give money, people hardly ever give it back. But it would be great. But I certainly wouldn't focus a study on increasing court fees, because that does have a devastating impact on low-income litigants. Thanks.
Governor Rathbone.
Thank you, President Angeville. I would just like to first say I am happy that the legislatures listened to my roundtable discussion from a few meetings ago where I discussed this exact issue about the access to justice due to the fact that we don't have a unified court system. With that said, I think one of the things I'm in support of this proposal. Where I do have some pause, however, is the impact on my rural community. I think practically when we look at a unified court system, great, wonderful, but there needs to be a legislative bill to fund it. And also, I think when we talk about stakeholders and if we're looking at information, we need to be talking to the smaller rural courts because, like Governor Couch pointed out, people are willing to do the work if they have the support. And I know, at least for my local county, while I don't work there every day, I think that might be a potential issue as far as do they have the manpower to support the change if this were to go through to the end and a unified court system was adopted. So while I do support the proposal to get more information and obtain facts, as Governor Ahern pointed out, I think it's also really important that when we're talking about what we look at for this proposal, we're not leaving out the smaller counties because the manpower, you can give them the money, but it's really the manpower issue of are they able to do it without without pulling the line completely. So I just want to add that and make sure that that's clear from my standpoint. Thank you.
Governor Bloom.
Yeah, I think you know, I don't have that much personal interaction with the court systems at the state level routinely, and but just kind of understanding the priorities as they're kind of stated, the proclamation on 114, 115. I think it might be better said, perhaps instead of increase existing court user fees, ensure adequate resources for the court systems or something to that effect, maybe. Because even the kind of the lead up, the main bullet point, monitor and take appropriate action. You know, is it appropriate to oppose increased fees or whatever? Because I mean, and as I understand, courts and user fees are sometimes subject to fee waiver in appropriate cases where there's hardship or things like that. Potentially, so I mean, there's that existing structure. But I guess one of my other kind of thoughts or questions is, I mean, so the study potentially would draw attention, certainly at the legislative level, the Supreme Court are, throughout the legal community. And then, but if this doesn't really gain traction, so potentially to the extent it's increases awareness at the legislator level, at the legislative level, then those folks are going to be socializing this among their constituencies and potentially publicizing this to the greater public at large. The question then is, how much effect is this going to have? I mean, is this going to ultimately or eventually lead to potential constitutional amendment? Is that a desired outcome? Is that a possible outcome? Do we have any kind of thoughts, or is this just kind of, this is out here and wherever it leads, we'll see? Because clearly, and I mean, that's the thing. It seems like if there's not a groundswell among the public to address this type of an issue, it's embedded in the Constitution. It's just an intractable problem. And so, the Supreme Court and the lower courts are at loggerheads, and it just continues apace. So, I mean, the thought of the study, yeah, it kind of raises it. It increases the understanding and knowledge of the facts, right? That Governor Ahern's point. And but if it doesn't resolve anything or it doesn't move the ball, then it's ultimately just kind of tweaking these particular issues with around court resources and potentially interoperability of technology platforms among the courts. So it's kind of ambiguous, and maybe we intend it to be that way, or we're okay with that. So that's just my observation. Thank you.
Yes.
Governor Bloom, you you spoke about some language changes, and I just wanted to know whether you were intending to make a motion to amend, to adopt that, or were you just, that's what I was trying to understand.
Yeah, I guess just for consideration, I mean, I'm not suggesting we have to, because appropriate action leaves enough kind of ambiguity about how we feel about increases and decreases in fees, I guess. So, I mean, maybe we're not locking ourselves down the way it's phrased, but it seems to me as though a more general form. So I would defer on this, whether somebody wanted to offer an amendment to that effect.
Governor Williams Ruth, and then Chief Nagowski, and then Governor Ahern.
So I don't think we need to go through resolution and changing things. I mean, it covers the gist of it. Could it be better? Could it be worse? Sure. But resolutions, I like the fact that just the therefore clause is where it's at, because there could be 1,000 whereas clauses to do this. But first, I want to say what I think the answer should be, which is to upset every state entity and go for a state-run ECF. The federal filing system is smooth, it's perfect, it's wonderful. You can add in district courts. I mean, it can grow when you have the little ones, and that way no one gets to claim that they won. King County, a lot of people believe Pierce County Links is actually the best electronic system out there. So I just think that they're all going to need to give up and go for a federal run system run by the state, but that's neither here nor there. What I would love to see is, one, I like the commitment that the bar is not going to be the one leading this, but I think we are the people that have the information, including, and I know Governor Ahern was there, and Tara and President Angelo last year at the Access to Justice Conference. I think 70% of the speakers in all their different categories were the facts regarding why it's there. So I hope that Representative Taylor and the staff and whoever are going to be behind this reach out to Diana and the Access to Justice Board and just say, can you give us all the ATJ? Because she was there. Representative Taylor spoke as one of the keynote speakers. And, it came back to me from our affinity dinner on Wednesday night, how impactful that conference was. And again, the facts that each of those subject matter experts have already at their disposal. So hopefully they're not going to recreate and ask people to come up with, I don't want it in an Excel spreadsheet. I want it in a Google format, whatever, because the data is there. It just needs to be brought together and served up on a nice little formatted report for the legislature. So number two, I really would love to see the unwritten rules go away. Specifically, Pierce County, to open a probate, you must list the age and birth date of an executor. It's nowhere in any rule, but if you don't have it, they will reject your filing and send it back. That costs money to your clients. Yakima County, I tried to appear for one probate matter in Yakima County. Because I didn't live in Yakima County, I could only look at the docket through Odyssey. I couldn't actually e-file. I had to manually, but where is that in a rule? It's not, because our local systems are sadly built around hometowning their people and giving them the advantage. And that's going to go away. So I want to hope that as that all of these unwritten rules get brought out and shown a light on, and either codify them in a new rule or say, you know what, you can't do this. And violating these rules means that you're going to get, there is accountability, favorite word, up the chain for when you are increasing the costs for the public. And then the last is just to say, I hope that I'm wrong. I really do hope that there's a result, because this is a significant issue. I mean, when I was a litigator, before I did my current practice, 100% of my practice was in the federal courts. And when we pro-hocked into a matter in Colorado, it was the same. The interface was the same. Literally all that changed was that the seal at the top of the website that said the district court for the state of Colorado. But then the actual interface is the same. The rules are the same. You can file anything up until 11:59 p.m. and it gets filed on that day in Maine, in Arizona, in Hawaii, and in Guam. So the benefits of our practice, as more of us are wanting to help with the legal deserts, but then being tripped up, and now it's not perfect. I mean, Eastern District of Washington, you have to file it in 14-point font. Can I tell you that as I was reading all the local rules for the first time I ever had to file in the Eastern District of Washington, I didn't look at the font size because I thought but they're older judges and they need the larger print. Fine. In a moment for Judge Quackenbush, thank you for your service. You were an amazing public servant. Anyway, so, it's not the end of the world, but I think it's amazing. I'm glad that we have legislative support. I just hope it doesn't end up being compiled and then sit, because the end result, Governor Bloom, is, I believe, yes, it will require a constitutional amendment. And whether it's not the right time and they're going to sit on it for 5 years, it is the necessary step. I'm glad that it's out there on the public, that we, the WSBA, will not be the ones having to invest all the time, because, there's that scope creep where those unfunded mandates come back. And then when the realization is that the brain trust of all the people, and again, I'm looking at the people in this room that know all the contacts, that have the local connections, it's going to be really easy for people to just be like, why don't you just go ahead and take that lead? You know these people, great. And I'm glad that we're saying that's not the intent. That's not what we're going to allow to happen. Thank you.
Thank you, Governor Williams-Ruth. Chief Nagowski, then Governor Ahern, then Governor Arneson.
I'm glad that Brent just went again, because I was going to look at you and say, Brent, this is the get rid of, put your birthday on it. But like, you are living in my head. So to hear you be the first out of the gate to say, like, what are we doing? It's like, wow, this is my stop the weird unwritten local rules that you have come again and again and said. This is my moonshot. As Director Nevitt said, I was supporting you. I wanted to put this as a strategic goal yesterday, but in some ways I also agree. I don't think the WSBA is positioned to carry the onus and to be the leading edge of this sword. However, there is real momentum to at least begin to talk about this in a real way. And I think what the WSBA is uniquely positioned to do is to gather the evidence and the data of harm. And we hear again and again, we've heard it around this table, we hear it again and again when we go out. I believe that those running the court system maybe are invested in the way things are. I think the people being harmed have no clue in the ways that they're being harmed. They don't know they're being charged more because somebody can't cross into a jurisdiction or their things are delayed or whatever. But I think 42,000 members who are using the court systems and encounter the inefficiencies and the inequities every day are really the people who've got the data and the stories to put together. And so I am actually really excited to have a germane piece of advocacy that I think our members are going to really fully support. I don't think we're presuming solutions, but I think that we have ample evidence that we can put together the data of actual harm and inefficiencies that will be very hard for people to refute, to say, I want to just bunker down and continue with the things that they are. And I think that's what I've heard, especially from some of the legislators, is that if we have some compelling reasons to show, that my constituents are being heard, this is going to be really compelling for the legislature to act upon. So I'm excited about it.
Thank you, Chief Nagowski. Governor Ahern.
Okay, 3 points. Thank you, Brent, for letting me, in our last meeting together, disagree with you on something. I disagree that it would require a constitutional amendment to get the result I think we're all looking for. I think you can have preemptive Supreme Court rules that get rid of these unwritten things, and I've had bad experiences too with those, or just the different rules in different counties and all those kinds of things. You can have funding appropriations that either do fund things or provide that carrot that especially the more cash-strapped counties are going to munch on immediately. Second point on the point about monitoring and make appropriate action on increased fees and why would we ever support increased fees? I myself would probably support increasing fees if it was done on a part of a sliding scale system where the more wealthy folks paid higher fees and the poorer folks paid lower fees. And I think that would be an access to justice issue too. My third point though is this is not perfect, but I think it's a very good and very important first step moving forward. And so I would support just leaving it as it is written and going forward.
Thank you, Governor Ahern. Governor Arneson.
I feel compelled to stick up for my Eastern Washington judges a little bit. But the point is well taken, that there are a number of things you don't know until you practice in a certain area. I'll say I'm strongly in favor of the study, in particular because the WSBA will not be the one doing it, but we will benefit from the outcome of it tremendously. I just want to point out on behalf of a lot of the smaller rural counties that a lot of those local rules have really good reasons for being there. I don't want us to fall into the trap of saying that they're there for no reason or to impose our idea of their intentions in putting them in place. Just to put that out there. I also want to point out that in Eastern Washington, there can be a lot of resentment for things that appear to be or feel like they are being imposed by Western Washington. Whether that's really what's happening or not, that is a real feeling that has real effects on a lot of folks in Eastern Washington. Because of that, I think it's really important that this study carefully do outreach and really consider the opinions of the folks in all of those counties. I believe there's a motion and a second on the table. I'd like to move to amend the motion that's on the table to add specific language to the proclamation in the therefore section to specifically call out that we need to make sure that the stakeholder input from all the rural counties is there. I don't know if you need specific language from me. I would be comfortable with letting staff come up with that language.
I would second that motion.
Thank you.
So now, Madam Chair, the date would be on
the
before
amendment,
you
right?
Then vote on the amendment.
Or would the person making the amendment consider it a friendly amendment?
There's actually no such
Thing
thing.
as a
Technically not
friendly
yet.
amendment.
What? Well, if you want to allow that, allow that. So I will leave it to you, Madam Chair.
Okay. Well, for now,
Is that a
we're,
friendly amendment?
is it a friendly
How do
amendment?
you
Yeah.
decide?
Person making.
Maybe it's cleaner to discuss and vote
Yeah,
on the
let's,
amendment.
I think it's cleaner to discuss. Let's do that. Let's discuss the amendment, please.
Could I just get clarity on the amendment? Sorry.
Of course.
I can restate
Okay. I was going to state it.
it. Okay, Emily, tell me if I've got this right. So to amend the proclamation to call out ensuring that stakeholders from Eastern Washington are consulted.
Specifically the rural counties.
Specifically the rural
Rural counties everywhere.
Oh, everywhere.
Yeah,
Okay.
yeah, yeah.
Right. Not Eastern Washington, rural counties.
yeah.
Statewide.
Right.
Yeah.
Got it. Got it.
Thank you. Yeah.
I got it.
Is it my decision? No.
We're debating.
We're debating,
Oh.
we're discussing. Yes, Governor Bloom.
Well, I mean, one of the things that had kind of occurred to me and before Governor Arneson's amendment or whatever was it seems like it's almost kind of a small town or rural issue with the local rules, whether memorialized or not, being an impediment to the ability for folks potentially to do remote representation or for being involved in cases outside of their normal jurisdiction, right? If somebody from within the 50 miles of I-5 wants to practice or do something in a small town rural part of the state where they're not familiar with those local rules, and therefore it creates an impediment to to legal services, to access to justice for the jurisdictions that would fall within our concept of small town or rural practice. And but the point being as well, that if there's a valid and good and valid reasons for local rules, then should these be considered as things that could enhance other localities as well, and that should be adopted more widely or broadly, and therefore that should take consideration by the Supreme Court if they're going to hand down no local rules, maybe take into consideration, maybe those should be adopted as part of uniform court rules then, or something of that nature.
Governor Rathbone.
Thank you. I actually have a hearing in about 6 minutes, but this is really important. So I'm staying on to say, I think Governor Arneson made a really good point, and I'm actually disappointed that I didn't take this a step further. And the reason why is to echo her comments that a lot of times these rural counties get left behind. And as far as making sure that they have input on this issue, I think is really important. I think my desire would be that they feel like they have a seat at the table, because oftentimes the trickle down through King County, and I'm going to call King County out, means that the smaller counties get left behind and they're not considered because they're not as they're not as well funded, and they're not as big, so their voices are smaller. And so I think this is important, and I have to sign off, but I would really urge the board to make sure that to consider this amendment for this proposal.
Thank you. Executive Director Nevin.
I just want to add, I heard you say that you'd be okay with us drafting something unless we wanted to draft it now. And I'll just say, like, I could imagine adding a new statement, and I might, instead of saying consulted, say something like meaningfully engaged, but I just want to make sure that everyone's comfortable with us taking that.
Yes, my main goal is to make sure that the voices of the rural counties are specifically called out in that action statement.
Mm-hmm. So now, Mr. Parliamentarian, we are now voting on the amendment.
Okay, so this is the amendment to have staff amend the proclamation to ensure that stakeholders from rural counties are meaningfully engaged in the process. Okay, Tom Ahern.
Yes.
Emily Arneson.
Yes.
Matthew Dresden.
Yes.
Nam Nguyen.
Yes.
Brent Williams-Ruth.
Yes.
Christina Larry. Kevin Fay.
Yes.
Kari Petrasic.
Yes.
Todd Bloom.
Aye.
Allison Whitney.
Yep.
Mary Rathbone, gone. Jordan Couch.
Aye.
Parvin Price.
Yes.
Elaine Villeneuve.
Yes.
All right, and then do we want to move to vote on the underlying motion as amended? Or is there further
Yeah.
discussion?
No, you would now be voting on the main motion.
Okay,
Okay,
main
we're
motion.
now voting on the main motion as it was just amended. So Tom Ahern,
Yes.
Emily Arneson,
Yes.
Matthew Dresden,
Yes.
Nam Nguyen,
Yes.
Brent Williams-Ruth,
Yes.
Christina Larry,
Yes.
Kevin Fay,
Yes.
Kari Petrasic,
Yes.
Todd Bloom,
Yes.
Allison Whitney.
Yep.
Mary Rathbone, not present. Jordan Couch,
Aye.
Parvin Price,
Yes.
Elaine Villeneuve.
Yes.
Motion passes unanimously as amended.
Great. Well done. Great discussion. Yes, Mr. Parliamentarian.
Sanjay, I'm glad you are still on, and I just had a question and a thought, and I'm saying this for all the governors and the executive director as well. There is an opportunity in this session to get sponsors. And so I hope there's a thought about having a sit down with the newly elected representative from the 7th District, who's a former president of WSBA, who may become, or at least to explore the possibility of him being one of the champions of a lot of the things that are in the legislative priorities. So I just want to put that on the record that it may be another area for Representative-elect Abel to become engaged with.
Thank you.
Can I
And
quickly add it to that? He already knows. There was a really fortuitous, he called me as we were speaking to Rep. Taylor, and so he got an earful already. Thank you.
Governor Petrosic.
And Sanjay, I just want to also inform you, I've been contacted by Senator Nikki Torres from the Tri-Cities. I'm not sure what district that is, but she also has a very invested interest in this. She wants to attend our STAR meetings and see how she can help as well. So there's
That's
another
wonderful.
advocate.
Liz Berry
Awesome.
too is interested in unified court stuff.
Good. Excellent. Coalitions.
Marcus Reese Shelley from Spokane is also very, very invested in this. He's the new senator from Spokane.
Okay.
Okay, Sanjay?
The
Governor
question
Webb?
is for Sanjay. Had you reached out to the incoming governor's staff and the incoming attorney general staff?
I have,
yeah.
not the incoming governor, but his potential chief of staff. So we're going to have a few conversations about a few
the
issues.
chief of staff's actually been named. So
Well, there you go.
It's the deputy. It's Shane Esquivel. Actually, pretty much everybody from his executive leadership team is joining him at the governor's office, including the legislative director and the policy director. It will be the same person as the AG.
Wonderful. So I've been speaking with Joyce Bruce a little bit, who I imagine will be the policy director, and we'll have those conversations as we go forward.
She's the legislative director. Sahar Fathi's the policy director.
I think we are now going to take a break until 11 o'clock. So our presenters are not here. Sorry.
Oh, we could do Governor Round.
Oh, yeah.
Yep.
Yeah. Let's do Governor Roundtable, but should we take a 5-minute break? Okay. All right, 15-minute break.